May it please the court, my name is Dylan Guynes, and along with my co-counsel, Avery Worley, we will be representing the respondent, the United States, in today's case. In my time before the court, I'll be arguing that the warrantless search of the cell site data collected from Timothy Carpenter's cell phone does not violate the Fourth Amendment because it falls under the Stored Communications Act. And my co-counsel will be arguing why the court should consider the third-party doctrine. One thing to bring to attention is that the United States Congress has specifically legislated on the question before us today. And in doing so, it was decided that the Stored Communications Act is considered a middle ground between full Fourth Amendment protection and no protection at all.
So, Counselor, absent the Stored Communications Act, is it your position that Mr. Carpenter would enjoy no protection under the Fourth Amendment, or that he would enjoy full protection? What I'm asking is Congress giving more protection to Carpenter through this act than he was initially due, or is it lessening what he was initially due?
Well, Your Honor, under the Stored Communications Act, whenever it is applied, both sides are put in the middle ground, and then they use the evidence to help. They use the evidence provided to choose which side that they would rule in favor of. The Stored Communications Act is a law that deals with the voluntarily and compelled disclosure of stored wire and electronic communications, as well as transactional records. Because Carpenter confessed to the crimes that he had been arrested for, and he voluntarily gave the FBI the reasonable grounds needed in order to gain access to these transactional records and the cell site location data, with the numbers that were given to them by Carpenter. The cell site data of Timothy Carpenter's phone was collected without the use of a warrant. However, the warrant in today's case is not needed because of the holding in Ex parte Jackson 1878, which stated that while the government needed a search warrant to open things such as letters and packages, they, however, did not need a warrant to use the names and addresses of the recipient as evidence. This is relevant to today's case because the FBI did not look into the information of the listed phone numbers. They only looked into their names and their locations. In response to this, Mr. Carpenter brings up the Supreme Court case of United States versus Jones, 2012, where it was decided that the use of a GPS tracking device on a person's vehicle constitutes as a warrantless search and a violation of the Fourth Amendment. However, the use of this holding in today's case is not appropriate because the use of a GPS tracker was never used.
Okay, so is this not appropriate because the government didn't put a tracking device on Mr. Carpenter, they just used something that was already on him? Or is it not appropriate because cell site location data is essentially different from GPS data? Why is that holding not appropriate in today's case?
Well, Your Honor, the difference is that in this case, they use the cell site data location of the cell towers, and GPS tracking deals with real-time location, while cell phone towers deal with past time.
Okay, so historical data is okay, but real-time surveillance would require a warrant.
Yes, Your Honor.
Okay.
And also that in this case, they put a tracker on his property, and in this case, we only use the evidence that we were legally able to use under the Stored Communications Act. Cell phones work by establishing a radio connection with the nearest cell tower in the vicinity. And in a large urban city, such as Detroit, this would be anywhere between half a mile to a 2-mile radius. This shows a distinct difference between a GPS tracker and the use of nearby cell phone towers. This case is unable to provide any precedent in today's case. It is because of these reasons that the cell site data, such as mailing addresses, phone numbers, and IP addresses, is considered information that facilitate personal communications rather than part of the content of those communications themselves. The government's collection of business records containing this data is therefore not considered a search under the Fourth Amendment. In conclusion, the FBI had full authorization for the search and seizure of the cell site data locations from Timothy Carpenter's cell phone because he voluntarily gave his confession as well as the cell phone numbers of his accomplices. Therefore, this case falls under the Stored Communications Act. I will now pass over to my co-counsel, Avery Worley.